Uh, Hello again. My name is Cesar Pereira. I'm the chair of the Chartered Institute of Arbitrators Brazil branch. At this opening here, I'm representing also the MAA, the Moot Alumni Association. And we are very honored to have here with us some of the big stars in the arbitration world and specifically in the Vis Moot world. We are going to discuss today one of the very important topics of the of how to structure an effective and useful moot competition, which is how one should behave as an arbitrator in a moot arbitration competition. It's a well-known fact that arbitrations rely heavily on the quality of arbitrators. And that's what we are going to discuss here today. What is a quality Vis Moot arbitrator, and how does that relate with real life arbitration and real life arbitrators? To discuss this very important topic, we have a group here that's extremely representative of the richness of this competition. We have Professor Petra Butler from Victoria University in Wellington, New Zealand. Christopher Key from Flinders University in Adelaide, Australia. Also a director of the Vis Moot. We have David Hubner, very experienced international arbitrator, a trustee of the Chartered Institute of Arbitrators, and extremely experienced as well as Vis Moot arbitrator. Professor Edgardo Munoz from the University Panamericana, Guadalajara in Mexico, a coach and an arbitrator both in real life and at the Vis Moot. We have Luisa Quintão, who was Moody until some years ago, now a coach, a practitioner, and despite of her young age, also an experienced Vis Moot arbitrator. Together with me here as a moderator for this program, we have Cristina Mastrobono, also a fellow of the Chartered Institute of Arbitrators and a committee member of the CIAb Brazil branch. What we intend to do here is cover some of the most important topics that seemed, well, at least some of the topics that seemed very important to all of us here when we were preparing this discussion. And Christina and I will go through some of them with the speakers, and as we arranged before, everyone is invited to jump in. I ask all the participants, if you have any questions, please use the Q&A function here on Zoom, and we will be very happy to address your questions. We have some time left or allocated for that at the end, but Christina and I will be looking at the Q&A section here and working your questions into the discussion as much as possible. Okay, well, so without taking any more of our speakers' time, I'd like to invite Christina, if you
So good night, everyone. Good morning, or good afternoon, good evening. Well, first of all, I'm very happy to be in this panel, in this webinar, to have the participation of so many important arbitrators and personalities of the Vis Moot competition. And well, just a few notes. We had an idea of organizing this webinar, because we noticed that we are in Vis Moot season. There are a lot of webinars aiming or directed to the students. And well, one of the important things and an important piece of the entire competition are also arbitrators. So the way they act, the way they serve can be decisive to the outcome of the dispute there, of the competition. And we all have been in Vienna, and we see that sometimes things don't go exactly how they should be, sometimes very well. Sometimes you learn a lot with other arbitrators, and sometimes you just think, well, is this right? What could I do now to fix this? But should I say something or not? Well, I don't want to anticipate the discussion, and I will start questioning to Professor Petra, referring the expectations regarding the arbitrator. So the big question is, what is expected of a good and effective arbitrator at the Vis Moot competition? So some of the arbitrators, they really assume an entertainer role. We don't know if that is good or not. So although it's good for the mood of the students, they kind of relax a little bit, but is that good or not? How relevant is the aspect of the role modeling for a Vis Moot arbitrator? So how important is an active participation of the arbitrator with questioning or commenting during the team's presentation? So does it enhance the student's experience, or does it defeat the purpose of giving the students center stage? So should the arbitrator's personality emerge mainly through the feedback or also during the hearing? So what are your thoughts about that?
Thank you so much, Christina and Cesar, for inviting me. And I'm really glad to be in a panel with so many friends, Vis Moot friends, so that's a great honor. An arbitrator, the key, from my perspective, also because I coached for a long time, the key competency of an arbitrator is be well prepared. And that must be the main thing you can do for being an effective arbitrator. Be incredibly well prepared, and I actually think the more pre-moots at this point of how the competition has evolved, the more pre-moots you can do as an arbitrator, the better, because you learn with every arbitration you judge yourself. So that for me is the key. The other key, because you asked the question about the entertainer, I think the other key is be authentic, be yourself. Don't try to be somebody you're not. That would be the same what I would tell the students though. But I think, so if you are a natural entertainer, just let your personality shine through. Yeah, life comes in all shapes and sizes. So does in real life the arbitrators. Not every arbitration is the same. It depends what your panel is. And one of the key things to learn also from students, I think this is what university is for, is to react and to be able to handle different personalities. So don't try to be somebody you are not. And that theme for me carries through in the other questions you asked me around, should you ask question, where are you coming through? Do you give more feedback at the end? Do you wait, or do you ask questions and interrupt students? I think overall, of course, you're trying to ask short and sweet questions. So that will also depend how the students have been coached. Now, my experience is that most students have been coached to expect questions quite a bit. So they often get very ruffled if they don't get any question. How many questions you asked is, I think, depends for me on the stage of the competition. So in a practice mood, in a pre-mood, I would tend to ask quite a good number of questions to give the students the opportunity to see this variety of questions they might get in Vienna or Hong Kong, so to be basically prepared. Sometimes I ask questions to actually also point out where arguments are weak, or where where they basically invite questions from arbitrator. The more you go into the competition, and basically the higher up the rounds are going, I think, the less questions you need to ask, and you probably sometimes should ask, because there is less opportunity than, I mean, in the quarterfinals and the semifinals, for example, for students to probably completely rewrite their submissions. I mean, there is so I'm using questions normally to also educate personally, and I'm looking forward what my co-arbitrators are saying, but basically to try to make the submissions of the students better. Yeah. So now the same would be true for feedback. I think it needs to be honest feedback. That doesn't mean you have to be cruel, but I think there's nothing worse for students than being told this was fantastic and then getting their scores back afterwards. And there's the same for coaches. And I always think, who is a competitor, a student now might be a coach next year. So there has to be a relationship between the feedback you give and the scores you're going to give. Because that creates certainty and reality for the students, as well as basically for the entire competition. And well, I think I want to stop there, and we might have more of a discussion now, because I saw Chris and Edgardo already kind of nodding or not nodding. So I'm kind of interested in them, what their views are and their experiences are. Thank you very much.
Thank you, Petra. Well, I think what is the question here is, how active should an arbitrator be? Yes, and because sometimes we notice that some are too proactive. Yes, and what you said is, I think, is very important. Yesterday I was reading my case. We took, Cesar and we took part in the pre-moot, in the Kansas CBC pre-moot, and I was so worried to find out which very difficult questions I wanted to ask. Yes, and then I suddenly said, you don't have to shine. The students have to shine. It's not your stage. You just keep it simple and you ask what you need to. I'm not an expert in CISG, so I will do my best. But this came so strong that, the students have to shine and not arbitrators. But unfortunately, not everyone has that in mind. So does anyone wants to comment on this question? Please.
Could I jump in just on a point there, and
yes,
just
please.
To reinforce and echo the observations that Petra and you have just made. I think it is absolutely essential as an arbitrator that you are properly and fully prepared. But as an arbitrator, being properly and fully prepared probably still means the students know more than you, because they will have been doing this for 6 months at least, and really, really, really in depth. So expect that the students will know more, but also being properly and fully prepared. And this comes to that point specifically, does not mean showing off that you are fully and properly prepared. One of the criticisms that, or concerns that teams sometimes raise with us after hearings is that they feel the arbitrators were trying to show off with how much they know. So it is finding that balance between how many questions that you are going to ask and the sort of the probing nature of some of the questions that you will ask. The questions that you ask as an arbitrator might differ depending on your assessment of the student. Sometimes you might ask, if you think the student's arguments are particularly sophisticated, you might ask a particularly sophisticated question. If they're not so sophisticated, you ask a question that allows them to draw out that sophistication in their argument because they haven't quite got it out there yet. But it's most certainly, as you've both been saying, it's most certainly not about us as arbitrators. it's an opportunity for the students. So as a rule of thumb, they need to speak more than the arbitrators.
Yeah, if I could jump in, Christina,
Please.
I agree with everything that's been said. I would boil it down to what our function is. I think each arbitrator in the moot should recognize he or she is there to contribute to the education and training of the students who've worked so hard to be there. That's our sole purpose. And so when it comes to questions like, should I be entertaining? Do I want to show off? I would suggest, particularly new arbitrators at the moot, think in each case, is this enhancing the educational experience of the student or not? And if it's not directly related to enhancing the educational experience, don't do it. Think twice. The other thing I would say is I still see sometimes seasoned arbitrators make a couple of mistakes. One is they ask questions about facts. They challenge facts. That's not the purpose of all of this. And number two, there is a sheet that explains the factors to be considered in scoring. It's really important to review that, even if you've been an arbitrator multiple times.
Okay, thank you very much, all of you.
Can I jump quickly in again?
Yes.
As I said, everybody needs to be authentic. One thing I've never done is I've never sat down, got familiar with a problem and then thought about what questions I would ask. I think if you're really well prepared, then you can listen to the students. And for me, the questions come automatically as a gut reaction to what the students are saying. And then I think you end up with what Chris was saying is, if you have a sophisticated team, your questions will be different from when you see you have a team that is kind of struggling a little bit and you need to draw out their sophistication. That makes you flexible. But this means you need to be incredibly familiar and well prepared, also with a record to be able to pick that up. So that's what I said. But in this, some arbitrators might feel more comfortable, of course, to have already a set of questions in mind. But yeah, that can potentially backfire a little bit.
Yeah, very interesting. Yes.
And Christina, if I can move into another topic that has to do with this one, and I think it's a very good transition. What Petra just said, that we are all in this first section here talking about how arbitrators should behave and how conscious they should be of how they should prepare and how they should behave. But my question now, and I'd like to ask Christopher about this, because I know you have some limited time to be here with us. And before I do that, let me just say that we have Sherlyn here with us. Sherlyn is a partner at Withers Worldwide in Hong Kong and deputy director of the Vis Moot. And so it's very good to have her with us as well. And so, Chris, when we are there at the competition, sitting there as arbitrators, we are on a panel with two other arbitrators, and many of these things that you were talking about just happen, and we have to deal with them as we do in real life with other arbitrators. And we can't really stop all the time and go to the separate room and talk among the arbitrators and come back to the room, right? We could in very extreme circumstances, but usually that's not what happens. And so my question is, how do you act as a presiding arbitrator or as a wing arbitrator, or as a co-arbitrator in those circumstances? First, maybe who should be chair? The most experienced arbitrator, the youngest arbitrator that will learn from the wings. What can you do as an arbitrator, either chair or wing, if something is not going according to plan, and maybe an arbitrator is asking too many questions, harassing students, maybe, if you can think of an extreme situation like that. So what's your view on how you should act as an arbitrator there on the spot?
Thank you, Cesar, and thank you, Christina, and thank you for inviting me onto the panel too. In terms of who should be chair, generally speaking, we choose or we'd want an experienced person to be the chair. When we're composing the panels, we try very hard to follow sort of various rules or guidelines in terms of how we compose a panel. We always try to have someone who's really quite experienced, someone with a sort of a mid-level experience, and someone who might be completely new. And when I say experience there, it's a combination of real life experience, but also moot experience. We also follow other rules, such as trying to get a mix of common law and civil law arbitrators in the panel. There are increasing numbers of people who identify as both common law and civil law, and so that makes that logistical challenge a little easier these days. But we do have a mixture, and it's typically the more experienced person who would be the chair. It's much easier when we're in person and you get to sort of stand next to each other and have the conversation to work out who's going to sit where. But there is the opportunity still with the online hearings for the arbitral panel to meet just before and to canvass a few of these issues, because I think you're right, they're very important issues to consider. So we would expect in that discussion the panel to work out who was going to chair. They might have a quick discussion about the level of questioning that they think it might be appropriate to ask. My personal view is that we're generally speaking two questions roughly to each oralist per arbitrator is already quite a lot. So in terms of the time available, so I wouldn't be encouraging much more than that, if more at all. When to come to that question around how do you manage it? If you're the chair and you feel that one of your co-arbitrators is going a little bit too far, it is possible to just sort of take control of the hearing and just say, right, I think we'll move on to the next issue, counsel, if you could do that, please, conscious of the time available, and just sort of really signal very clearly to everyone that it's time to move on. As a wing arbitrator, that can be harder, particularly if it's the chair who is doing the excessive questioning. There have been some of the techniques that I have seen used in that sort of circumstance have been for the wing arbitrator to jump in with a question of their own, but a question, basically a leading question, a question that gives the student a way out of that line of argument or that line of questioning, and essentially invites them to move on. So it's it can be quite a challenging question to pose. It's often needs to be a spontaneous question, like the sort that Petra was mentioning before. But if you can see what's the issue that the arbitrator who is constantly questioning is really trying to get to, you might phrase that in the question that you pose to the student, so that essentially they're left with a yes or no answer, and that's it, and we move on. So there's some challenges that can be around that, but that's one of the approaches that I would take. And that can be done in a fairly subtle way. That hopefully wouldn't create that bad feeling between the chair or the other co-arbitrator. And it also signals to the student that you're trying to help them move on. I'm keen to hear other people's views on this one as well.
Thank you, Chris. And one thing that I would like to tell you is, as you may have noticed, the title of this event is "The Art of Arbitrating" at the Moot, and that was definitely inspired by your book about the art of mooting. So that was one of the things that I was going to mention. And well, would anybody like to comment?
If I could jump in, Christopher's covered everything I would have said. One footnote, which is in 25 years or 20 years of mooting, I've on 2 occasions had a serious problem involving an arbitrator who was overly questioning just one student. And in both cases, I leaned over and whispered that I'd like a brief caucus. Now, I don't do that a lot, but in both cases, it had allowed for a break in what was, in my view, becoming abusive, and allowed the arbitrators to whisper a couple of things that diffused it and allowed us to move on.
Yeah, no, that's, oh, yeah, Shirley?
I actually just wanted to make one comment on this, a personal comment, because everything that Chris raised is absolutely right. But since I've got David here, David, you know I love to always share this story. This is just kind of, I was a Moody 2 years ago, probably more than a decade ago, and David was actually the chair of one of my elimination rounds in Vienna. And so I know my round didn't count into 2 of the rounds you've just mentioned, David, but I had a very abusive co-arbitrator who wouldn't let me answer any questions. And then when he did start answering me questions, he just peppered and peppered and peppered, trying to lead me down the wrong road. And as students, students are never going to say anything against the tribunal, and they're scared. And at that point, I wasn't as scared. I got annoyed. But what I really appreciated was David actually did step in. He didn't take everyone out for a caucus. He actually just stepped in and nicely turned to the arbitrator and just said, could you perhaps just first let her answer her questions? And I think the arbitrator that was hammering away wasn't doing it on purpose. He himself was so into the problem that he was getting emotional and also arguing. So I think the only reason why I want to raise this is because for arbitrators out there, the students remember. I will always remember that day. Of course you're going to remember if it's an elimination round, but I will now never forget David when it comes to somebody who I think can be good in a mock situation for the Vis Moot, to be a good presiding arbitrator, but it also has an impact professionally going forward because you know and you can see how individuals would be in a real life situation. I just wanted to share the story. Sorry.
Chris?
Thank you. So if I can come back in there and sort of pick up on those points because they're extremely relevant and actually tie it back to the first discussion point we're having as well. I think it's really critical for arbitrators to remember that the students don't have to win the case to win the moot. And so we can, as arbitrators, we can get really involved in the legal argument. And the legal argument is incredibly important. It's a significant, really significant factor. And hopefully we see some really extraordinary legal argument in front of us as arbitrators. But that's not the whole event for the students. And so we need to keep in mind, and it casts right back to an observation that David made at the beginning about what our role is as arbitrators and why we're there. And so I think that's really critical to keep in mind as we're moving through. Thank you.
Petra, please.
First, can I just say the same thing a little bit differently? Because I just had a conversation this morning with one of my colleagues who coached an international moot. This is not about who has the better legal argument. Yeah, so because what often happens is this natural kind of thing, if the problem, which sometimes happens, is not completely evenly weighed for both parties, yeah, you need to keep as an arbitrator that in mind. Yeah, so sometimes one side will have the easier argument, and what sometimes happens is that naturally then the arbitrator side with that party. So that's basically saying what Chris is saying, you know, this is a moot, this is an education experience, this is not a real case about, in that sense, winning or losing. And I think that is really, really important to remember, especially when it comes to feedback often.
Thank you. So, well, I think we can move on to the next question, keeping keeping in consistently with what David and Chris suggested. I can ask now Christina to move on to the next question.
Yes, I just want to comment. I think we learned now or reinforced that the art to be an arbitrator requires a lot of sensibility from the arbitrators to understand what stage that particular team is. Yes, I don't think you should. I don't know if this is wrong, but Cesar, forgive me for insisting in this team, but I think it's very important. I think the sensibility makes that you have one, not the same conduct in all the hearings you are taking part. So I think it's different if you are facing a team that has from a country that has a long tradition in taking part in the Vis Moot, and one hearing in which one of the teams is for the first time ever a team from that country is taking part of the competition. So because I experienced that in my first hearing in a Vis Moot, one of the teams was from an Eastern Europe country. It's first team ever from the country to take part in the team. And the arbitrator was very harsh, very difficult, and I felt so sorry for the team because they were completely lost in their presentation. But anyway, I think the sensibility is something that everyone has to keep in mind when arbitrating. But going forward, question number 3 goes to Edgardo. And I want to talk a little bit about when things go wrong, especially nowadays in which the hearings are mostly online still, virtual hearings, and a lot of things can go wrong with the technology. So what type of things can go wrong? Is there any general advice to avoid or fix these situations? What happens when one of the teams lose their connection? Should they go just by without video, just by voice? Should only by audio? And what if an arbitrator has a technical problem? Should the panel just go on with the 2 remaining? So these are some of the questions I bring to you, Edgardo. I cannot hear you.
I was joking. I was joking. No,
Yes.
I can hear you now. You mentioned things can go wrong, and Petra said, just be yourself. So I was just pretending my mic was not functioning. Yeah, many things can go wrong in terms of technology because...
And we were talking about the entertainer, right?
The entertainer, yes. Yes. I'm not that natural entertainer, but I try. One of the things that can go wrong, and we just commented on this, is that you mix up the time of your hearing. When you are in the physical world, for example, sometimes you mix up the room, right? Especially in Vienna, because you may be scheduled to be at the Juridicum, and then you are at Baker McKenzie or other firms there around. So, and especially now that we are, as David mentioned, also backstage, some countries have moved to saving lifetime. So be sure to go into these time converters and set the day of your hearing as well, in order to make sure at what time in your local time you are supposed to appear. So this is one of the things. Connections, problems with connections as well. Obviously, it's very useful that you do this quick test, connection test, prior to the hearing. There are connection tests organized by both moots as well. So it is very important that you use the same computer you intend to use the day of the hearing to do this connection test. You can obviously try the independent camera, microphone, etc. But in my experience, I think it works better when you use your laptop and you do it in front of your laptop, because sometimes the independent camera or microphone cannot work well. Are you listening to me correctly? Yes? Okay. And the two questions, Christiana, you made are very important, and I check the rules. I've been participating in the virtual Vis hearings for the last 2 years. And I think the rules have evolved a bit, but regarding the question whether what happens if one of the teams can have connection problems and he cannot put his camera on, or he puts the camera on and everything starts to freeze or etc. I checked the rules, and there is nothing about that, about the fact whether a student can continue only by audio. The rule says that the participants must have a camera available and the camera on, but it doesn't say anything about the possibility to continue just with your microphone, your audio. Obviously, I'm talking about here under the control of Charlene and Chris know better the rules. And I remember that this happens in the first edition of the virtual world. And what we did at that time, the arbitrators, we allowed one of the teams to compete only with the audio. And why did we allow this? Because we thought that it was very fair for the other team to at least listen to what they wanted to say or the arguments they had prepared. But I'm not sure that we took the right approach. Probably we committed a mistake, but that was the first edition of the virtual moots. What happens if an arbitrator loses connection? Well, the rules, check rules 22 to 25, 21 to 25 of the virtual hearings. It's very clear if an arbitrator, well, if a team has connection problems, the arbitrators can wait up to a reasonable time, I think 2 hours, and actually put 1 hour extra if the connection problems continue with the teams. But if an arbitrator is not able to connect or has problems with the connection, I think the 2 other arbitrators must wait or can continue. And if a second arbitrator has problems longer than 15 minutes, then probably the hearing will be canceled, or no, the hearing will continue and the sole arbitrator will make an average score for them. This is what I remember and what I reviewed before coming to this webinar. But to be sure, check rules 21 to 25 of the virtual hearing rules available in the Vienna website. Thank you, Christiana, and thank you very much for the invitation, by the way.
Thank you, Edgardo. Christopher, please.
Thank you very much. And apologies that I'm going to have to leave very shortly, but thank you, Edgardo, for taking us through those. One of the things that you'll find in the Vis side of things is that there are sort of room assistants of a sort. So the IDRC, are the platform that we use to are helping us with the hosting of the moot again this year. And they will have room technicians and assistants who will be able to provide a certain level of technical assistance in terms of helping people get into the rooms and out of them. But there'll also be an avenue where if something has gone wrong, that you can pass the information back to us. When you face these sorts of technical issues, our approach is really adopt a common sense one as an arbitrator. It's really, if the moot can continue in some way, then please enable it to do so. But ensure you're in communication with us as an organisation, because one of the the big challenges for us is when arbitrators have thought they're doing the right thing, but they've taken fairly dramatic steps, and we find out later that certain things have gone on that we would have preferred to have done a different way. So it is important that you do sort of keep that line of contact if something has been delayed. As you say, Edgardo, there is the potential to extend the time available. That's one of the beauties of an online environment. We're not restricted to the rooms, physically getting people in and out of the rooms in the same sort of way as we had been previously. But even so, there are a certain number of Zoom rooms available, and they have to be managed. So it is just important that we do maintain that line of contact. We will have backup lines of contact and methods of contact available for arbitrators throughout the moot. So, for example, we'll have the channels available, the Slack channel available for the reserve arbitrators and the like. And that's one way of getting in touch with us if you're not able to contact your room operator, but there will be that possibility. The key thing from our point of view as an organisation is communication and not us knowing what's going on in those rooms. Apologies that I have to leave, but thank you all very much for allowing me to join. I look forward to reviewing the rest of the video and seeing the rest of the conversation. Thank you.
Thank you
Chris.
very much. Thank you. Cesar, I think you may go on.
Well, would anybody like to comment on this topic before we move on? Okay. Well, the next question I'd like to raise is directed to David, and actually it's directed to David because of one of those things like what Sherlyn mentioned. He probably doesn't remember, but we were together years ago in a semi-final at the Vis East, and at the end, well, so we were both there, and I think the chair was I don't remember. I think you were the chair, and the two wings were a lady from India, I think, and myself, and then at the end, we had completely different views about who had won. And it was funny because we both said something like, "Oh, that's very easy. This is clear." And then he went in one direction and I went in the completely opposite direction. Of course, he was right and I was wrong. and we decided, and then we had a unanimous decision according to what he had suggested. And I think that illustrates the idea of how to judge a team or an oralist at the moot. And so what relevance, we were talking before, what relevance do you give, if any, to who should win the case? And it may not be so obvious that you should give no relevance to that, because it may be part of the argument, what points you choose to submit, right? And so that may be something to judge or not. In like that, there are many things that you could consider when judging a team and an oralist. And I'd like to leave it to David to address them. Please, David.
Certainly. And Cesar and Christina, I'll join everyone else in thanking you for your entrepreneurial spirit in setting this up. As I say to other branches of the Chartered Institute, I'm impressed with the Brazil branch and how quickly it's become one of the most dynamic in our network. And it's because of programs like this. Also, Sherlyn and Cesar, I remember both of the arguments you described. I rarely forget a moot argument, particularly the fun ones and the traumatic ones. In terms of judging standards, it is really difficult because there is an urge to be drawn toward the winning argument, who's got the law on their side. And what we have to remember is that this isn't what the moot's about. Now, I tend to judge based on what the oralist does with the argument she's stuck with. And it is often the case that the most impressive oralists to me are the ones who have the weaker argument on the law, but are more creative, more well organized, and more tenacious in presenting their case with the clearly deficient legal posture they're stuck with. And I think that can be difficult, particularly for new arbitrators to really focus on. It's not, you don't judge based on whether somebody starts the race 50 yards ahead. You judge based on how fast and far they go with what they've got. In terms of standards, I think it's important for arbitrators to really read the description of the standards that we are given by the moot, because they tend to be clear, they tend to be very useful, and it helps get us past this question of harmonization. I don't particularly favor arbitrators at the end trying to end up with the same score that they give. I much prefer a short conversation in advance so that we get to know each other a little. We talk about the standards so that we can identify if one of us is misunderstanding the role or misunderstanding the standards. And I think that's much more valuable than trying to agree on the same score at the end, because doing it at the end means the stronger personality is likely to prevail, even if he or she is wrong on what they're doing. It also helps us, Cesar, get past or to reconcile differences in culture. Again, I think that's better done at the beginning so we can have a general conversation rather than be forced to have the conversation at the end in the context of advocating for a particular position or advocating for a particular score. In terms of whether the standards stay the same all the way through the process, I tend to apply the same standard in the final that I do in the first moot I do on Monday or Tuesday. But having said that, there really should be higher levels of performance generally as any team proceeds, because you are learning from what you've just been through. Now, I don't know if that answers your question. I'm happy if I missed a subpart to address it.
Oh, thank you, David. That was very good. And would anybody like to comment? Yes, Petra?
Yes, sorry, David, because I disagree. So I kind of wanted to comment. I thought that the new rules actually compelled the tribunal to have a conversation at the end around the judging and giving the points, because to avoid, which again goes to the legitimacy of the moot and the entire grading system, to have vastly different grades. And if you have, as a coach, we're on the receiving end, yeah, and since we're talking about experiences, we had a moot where one of my students got 49 out of, this was still when we were grading out of 50, yeah? So 49, 49, and then a 38. And that basically puts the 30, that can be the make and break actually in the end. Probably not was 40, 49, and 38, but basically to get into the final rounds, yeah, if you have 130 in it, that is the end. And it was, the question is, how could, after two arbitrators was 49, get a third one giving 38? That is pretty unlikely. And I think there were quite a good number, my understandings, of complaints around this. And this is why my understanding is that now there needs to be a kind of conferring at the end among the arbitrators. That doesn't mean, I heard you about strong personalities, basically telling everybody what to do. I don't think if you're a really good chair, that's what you're doing. Yeah, but this is, you are, I think you're at least giving from your experience, if we, as we heard Chris, the chairs are the more experienced one. If you heard some pre-moots, then you, I think, at least can agree on where you at. Are you on the top higher end or on the middle end or so on, so that you get some consistency, but you don't get these widely different grades.
Yeah, and Petra, we are not disagreeing at all. My objection, because I've been in some moot panels where there's an attempt to get to the same score, but I agree with you. And in all of the panels that I'm involved in, I find value and actually provoke the conversation about generally where we think people fall, so that we can identify and have a conversation if there's a wide divergence. I just don't favor trying to reach the same score, which I've seen some chairs do. The other value to doing what you and I are both sort of suggesting at the end, I continue to be surprised that there is unconscious bias that infects some arbitrators' perception of oralists. And one of the ways to flush that out and deal with it is to have the general conversation. I continue to see some bias toward what might be considered attractive oralists, or oralists with pleasant voices. There is a distinct bias toward, I find, toward male oralists. And the conversation you're suggesting allows us to determine if we're worried about a bias.
I agree.
Yes, Charlene. Oh. Yeah, Charlene and Luisa.
I'm just going to confirm something really quick with respect to the rules. Yes, I just reviewed it again yesterday. Arbitrators are encouraged, they will have their 10-minute or 15-minute deliberation to speak to one another about the scores. At least in the Vis East rules, that you don't have to come to the same scores. That's not the goal. But if there is a discrepancy of more than 10 points within the tribunal, the directors actually reach out to the tribunal to reconfirm that was the purpose. So just to confirm that, and I'm assuming Vienna also has the same rules.
Thank you. Luisa?
Yeah, sure. Just to link what we're talking about now with regards to what to grade and how to grade, to what Chris was talking about earlier in terms of what is possible to grade, and also about the function of the wing arbitrator or the president of the arbitral tribunal. So if during the hearing it wasn't possible to do something like David did in Sherlin's hearing and call the attention of that tribunal to something they might be doing wrong that they may affect their grade, is that you take that moment of deliberation to discuss that, and then the arbitrators have actually the opportunity to point to the other arbitrators something that they might have understood wrong, some misinterpretation of fact, some limitation of the problem that some arbitrator might be taken into account to grade that student, and that shouldn't be taken. So the importance of getting together and deliberating also affects the actual substance of the grade. And just to touch something that I was going to touch on when we were to talk about feedback, and feedback in this goes with what you grade. You can't grade things that someone can't change. So you can't, at least in my opinion, someone's accent shouldn't be the subject. You shouldn't be grading someone based on their accent. I remember once one of my colleagues received feedback. I'm not sure if you can even call that feedback, about their height. And maybe you should use something under your seat to make yourself look taller. I'm not sure if that's appropriate. So when I think about what to grade and not to grade, the first question, perhaps the most obvious one, you can't grade something that person has no freedom to change, that it's outside their control.
Well, I'm delighted you raised those points, Louisa. It's important to recognize those kind of problems and deal with them. Now, I know we're going to get to feedback later, but Cesar, in terms of questions and judging, just on the topic you raised, I think the questions you ask can be very useful in forming an opinion about the quality of the argument being offered. I sometimes see, though, arbitrators use questions, perhaps inadvertently, as a way of delivering feedback. And I think that's not appropriate. To use a question after a question after a question to be sending a signal about your view of the oralist performance or of the oralist arguments. There is a time for feedback, but I don't think it's in the middle of an oralist's presentation, tarted up as a question.
Excellent. Thank you. Well, I think with that, I will give the floor back to Christina. Thank you.
Okay, let's move on to the feedback question. Yes. So how important, and Luisa, you are very close to Moody's. Yes, I think you are still mentoring. Yes. So how important is the feedback? And what I always wonder is, do students really listen to it? And is there a difference in feedback in the pre-moots or during the moot? So in your experience, have you seen teams incorporating specific feedback into their next rounds? So what, in general, how do you think feedback should be?
Thank you, Christina. And now, because this is my first lead, now I thank you both, you and Cesar, for inviting me. I'm pretty sure I was invited to be a co-panelist with all these stellar Vis arbitrators because I can bring the Moody perspective. There's no other reason. Not so long ago, I was mooting, so maybe you invited me to answer this question exactly. Do we actually do anything about the feedback that is provided to us when we're students? And I say we as students, when I was doing the Vis maybe almost 10 years ago, but I still feel like I'm part of it. And I don't mean to take any credit for the PUC São Paulo's team, as much as I still consider myself part of the team. In the last few months, I've been distanced for obvious reasons, change of countries and all that. But well, your first question is how important it is to give feedback. In my experience, and I think this should be common ground for everybody right now, it's majorly important. So if you think about it, ideally, every time a team is judged, they're going to be judged by someone that's hearing their arguments for the first time. So we know sometimes because of the amount of pre-moots and all the rounds that we have that we might be judged by the same arbitrator more than once. But truth is that ideally they'll be hearing us for the first time. So imagine now a world with no arbitrator's feedback. Teams are left with their intra-team feedback. So the people that worked with them on their arguments and their self-evaluation. And I think there are limitations to all that. We have our own biases concerning our team's research. Of course, what I see in myself might be repetitive. I might not see things in myself that other people that are seeing me for the first time will spot. So on the importance of feedback, I think that's what makes it obvious. It's how the students perceive how their arguments are being received and welcomed by the arbitrators, and it's how they're going to shape their next rounds. So I do think students, yes, they incorporate feedbacks, but they're going to filter the feedbacks, of course. And I think the first filter is that question: what can I actually do about this? Is that something that I can't change? I mentioned about the voice, but also with regards to the substance of arguments, are there limitations to these problems? Can I even argue that? Do the facts allow me? And maybe that arbitrator is not that familiar with the facts as you are. As Chris said, we have to be prepared, but mostly the students will know more about the case than the arbitrators will. So they will filter the arguments considering in that as well. And also they'll ask the questions, will these constructive feedback always make sense? So sometimes I think David was mentioning something here about cultural backgrounds. So some arbitrators will give feedback, and I've heard a zillion times that German arbitrators are strict with time. and that Latin American arbitrators love passionate arguments. So sometimes when you're giving that feedback, I think it's helpful if you're an arbitrator to say, this might be because of my culture, and this might not be the solution for every case. If you're facing a tribunal with a slightly different cultural background, or if you have everybody, you have to try and please everyone. When you're a student, I don't think it comes that obvious to us that, oh, maybe now that this guy says I have to speak louder, I'll speak louder every time. So with time, students learn how to filter and adapt the feedback to each panel that they will face. But in general, I think arbitrators can themselves do that work and see what's their own biases with regards to the right argument, to the right style of advocacy. And because I like to have conversations, and Gada just raised his hand, and before I even continue, I would love to hear his opinion, especially because he's a professor that admires so much, and I can't wait.
Thank you, Lisa. I didn't intend to interrupt you. I was not meant to interrupt. I wanted to wait until you finish, but I think you are totally right. I think feedback is very important for students, very, very important. What you tell the students that the feedback can mark them for their whole life. And I think to give a good feedback, you need to be coherent with what you did as an arbitrator during the hearing as well. So you need to be prepared as an arbitrator, and then give feedback that is coherent with what you did as an arbitrator, because sometimes it's unfair that there are arbitrators that do not know the case, do not ask questions, or ask questions that are evidently wrong because they mix up the facts, and then the feedback comes and they are very harsh with the teams, right? As a coach, I always prepare my students for the feedback. I tell them every arbitrator sees things differently. You should not take this personal, because otherwise they can be really, they can come out from the room or the computer setting very, very annoyed, or yes, you know what I mean. So I wanted to say that, Lisa, you are totally right.
Yeah, I think David also has a comment here.
Yeah, I was just jumping in, so Edgardo would be distracted by a hand as well while he was answering. But I wasn't trying to jump in front. One point that I would add to the excellent comments you've both made, it's not what the arbitrator says that matters. It's what the student hears. And therefore, I would suggest that arbitrators in a moot need to be particularly intelligent emotionally and frame their feedback so that it is received and utilized, and there are two things that I do on that. One, myself, I don't do what a lot of other arbitrators do in the moot, which is go oralist by oralist and give specific feedback. To me, that's too assaultive, particularly if I have something negative to say. I make a few general points to the whole group so that they hear the points and can take it for what it's worth. Now, the other issue is when I do have specific concern about an oralist performance, I often will convey that after the session is over to the coach or to the oralist privately, so that they have the benefit of the comment without the embarrassment of a seemingly negative comment being made in front of other people.
I hear you, David, and especially, well, I can think of some types of arguments that of feedback that would be more frustrating to hear in front of an audience than others. And that brings us to the other point that Christina was mentioning, which is what the focus of your feedback should be. Should an arbitrator focus more on oral advocacy and or arguments, the substance of the arguments or the framing of the arguments? I think there's no one size fits all solution here. I think it would depend on the hearing and what those teams were lacking in terms of preparation. One thing we could say, and I think Petra mentioned something in line of this at the beginning, on how you give feedback can also be through your questions, through how you behave on the hearings. So perhaps if you want to focus on substantive issues of those arguments, or provoke that team to think about other strategies, you can make that through questions and then leave specific feedback on oral advocacy at the end, because I think it's harder to do that through questions. And so the answer is not that clear. It depends. But I think what David said about an arbitrator's function in the Vis being educational. So when you think about what you're going to give as feedback, think about how you're actually going to be helping that team evolve in an educational sense. How do they grow from there? So once you spot the issue, you help them grow, you raise your hand. And if there's a difference between the pre-moot or the moot itself, I'd say yes and no, or no and yes. No, because I think you should give feedback every time if there's something wrong, especially if something really bothers you. You should do that. But also when you think about the stage of the competition, what you expect from teams in terms of level of argument, that can alter what you're going to say in your feedback. But mostly time, which is available for the teams to work on something. So if you're talking about a semifinal round that is taking place less than 24 hours before the final round, there's only so much they can do within that period of time. So you might have to be more surgical then. And I think that's all my side. And more, but we can just chat.
Well, actually, we have one more question about feedback, and Christine and I thought that feedback was such an important aspect of the arbitrator's role in the moots that we intended to deepen the discussion about feedback. And this is an open question. It's not directed to anybody specifically, but it has to do what we were talking about. How do you teach through the moot with the feedback, and how do you give useful and constructive feedback? We talked about some bad examples, right, of feedback that's not constructive, that actually can be damaging. Edgardo mentioned that students can be devastated by some things that are said, and need, even as Edgardo said, have to be prepared in advance not to take things personally. The fact that we do have to tell students that shows that this is something that needs to be addressed, right? That feedback needs to be taken seriously. And some say coaching manuals will tell you that that compliments may be more effective than negative comments in order to prompt improvement. And so how do you see that? Do you, in my experience, we tend to tell the students what they should do better, even if we talk in general, but we tend to focus on what has to improve. And do you think that's something that we should rethink? Is it just a matter of how to do it, and how to point out what the weak aspects are that need to have some more work done? So how do you see that? How do we give constructive feedback, and how do we most of all teach through the moot? Anybody?
I can think of one way, and maybe that's being too specific, but if you think about one of the skills that all lawyers must have is issue spotting. And I think the Moot and the Moot exercise provide a great opportunity to help students develop that skill of issue spotting. And sometimes in a hearing of a Moot context, I think provoking the students with questions and making them think. So sometimes you don't even have to say there is this other theory, or maybe you should change your strategy to this other way, but just putting facts and circumstances that may also have an effect on their argument, I think help develop that skill of issue spotting. And in terms of how you think, in what you're talking about, should I give constructive feedback, or should I just say something that was well done? I think for the sake of time, usually you want to focus on what's constructive, but I don't think we can ignore the power of affirmation. And once we hear that we're doing something right, we'll keep doing that. And sometimes if there are only wrong things that are pointed at us, we forgot about the things that we're doing right. And maybe next time we don't think about it that much. So I agree with you. I agree with the power of affirmation.
But you talked before, Luisa, about how students take feedback and how important it is for them. Do you think there is an expectation on the part of the students to be told what to do better, and not simply to be complimented for what they did right?
I think it depends highly on your personality. I think there is a lawyer phenomenon that we like to be complimented on what the things are, right? Maybe it's a litigator issue because we like to win, or because we're always in this dichotomy of win and lose in cases. Sometimes they split the baby, they say, but I'm not sure if there's an expectation that they will only hear bad things. Some people like to hear compliments. I'm not sure if I have an answer for that.
Petra.
Yeah, I think I'm coming back to my theme from the beginning, that first of all, arbitrators need to be authentic. So the way you conduct your arbitration, I think that has come up from somebody else mentioned that, what questions you ask and what feedback you're giving needs to be basically yourself. And if you are in the mood because of the mood spirit, because you really believe in the endeavor, then actually you can't go wrong, because everybody will be different, so will be every team. Now, one would hope that that sometimes maybe needs some guidance, that if you have a little bit of emotional intelligence, you will of course try to say and cater your feedback to the teams in front of you. And I had teams like our New Zealand teams are highly competitive and generally very good. Of course, they're not there. It doesn't help to say, oh, you were fantastic, and then don't give any negative feedback, because that's what they want to grow. You have our teams who were the first time from their country in the mood. And if I would have really given them the feedback what they were doing wrong, that would have been devastating. So you model your feedback also in the teams. You're trying to figure out, what team is in front of you and what they need as encouragement to come back the next year and to actually bring the Vis Moot spirit back to their country and next to the next generation of Mooties. The only thing I think from a coaching point of view, and at least from my students' point of view, the worst you can do is to say it was fantastic. As I said, and I said this at the beginning, this was fantastic, and then you score really lowly. Yeah. So what you need to learn is that also the feedback you give is consistent with the score you're going to give, because otherwise there is no certainty, and that undermines, I think, the entire mood.
And David, please.
Yeah, I completely agree with Petra on that. Two points I would make, though. Feedback should not be about a performance. It should be about enhancing the experience of the Moodies. And that's why I continue to argue to some of my colleagues that having a separate feedback session and these are brief. I'm not talking about scheduling a half an hour conversation, but pulling aside a coach or pulling aside a team out of the view of everybody sitting in the room can be a very effective way to increase the educational value of the moot and convey some things that probably should not be said in front of others because of the risk of damaging confidence, which is really important. Many of the arbitrators have been doing what they're doing for 30 years and have developed rhinoceros skin. Students don't naturally all have that, and we need to be sensitive to that. The other issue with feedback, and I continue to be startled by this, we have to be very careful as arbitrators to be hypersensitive to the bias we bring to the judging. It is a serious problem. It's not talked about enough. And it's not just gender or race or sexual orientation. It could also be one's natural advocacy orientation in one's practice jurisdiction. We need to be sensitive to all of these dynamics which create different kinds of advocacy and might actually be distorting our evaluation of an individual or a team.
I asked you a question before about what an arbitrator could do during the argument in reaction to some of the things that other arbitrators do and that may not be the right way to behave. But that can come up also during the feedback session, right? You may watch one of your co-arbitrators do something that you feel can be even damaging to the students. And have you seen that happen? And how do you think you should react? Is that something to say, or should you just end the session there and just move on and have a chat with the oralist saying, look, that's not how everybody thinks? Or how do you handle a situation like that?
I'm sorry for jumping ahead of any hands, but I had one particularly egregious case where a wing arbitrator slipped clearly and referred to a female oralist as honey. And that's just extraordinary in this day and age. If that were to be taken under submission and dealt with privately, it would have reinforced a message that shouldn't have been given. So what I did was the next two times I referred to my wing, I called him honey, which made the point. But I think we really need to, in terms of inappropriateness, send a signal that the students recognize that something inappropriate just occurred.
Yeah, agreed. Yeah, and just to pick up on something Luisa said before, since this is at least the actual moot and generally the pre-moots, since they are competitions and the students are looking for correct grades and are looking to win, I think it should, if you are aware of something like that, you should make sure that that does not affect the grades that the students will get, and make sure your wing arbitrator realizes that those things are maybe wrong and does not reflect them on the grades. Christina, back to you. Thank you.
Okay, let's move on. Still about the performance of the arbitrators. And here comes an important question. Should there be an evaluation system for the arbitrators? Yes. Some competitions have been trying a sort of arbitrator intelligence feedback to guide future appointments. Does that make sense? Should we try to incorporate some participation of the teams in the definition of tribunals? For instance, if teams are asked to rank all or some of the Vis Moot arbitrators before the competition, could and should that be considered in the assignment of arbitrators to their hearings? Could there be an arbitrator selection process like that? for the eliminations round only? Should arbitrators be asked to give feedback on their co-arbitrators? And finally, should there be, or is there already, we don't know about that, a panel for arbitrators that can be presiding arbitrators in the competition? Or should tribunals be free to choose the chair among themselves? So, who is starting?
If I may. I think these are very difficult questions, especially from the perspective of the organizers, because usually the organizer is lacking arbitrators, especially in big competitions like Vienna, also Hong Kong. There will be many former muties, alumni, who became arbitrators just after they did the previous years as muties. And those of us who have been in the mood, some of the times we profile this probably wrong, right? We just say, oh, this is just a new arbitrator who was former muty last year. They are very tough some of the times because they read the case, they want to be in the other side of the table. Some coaches are very tough as well because they know the cases very well. And then there are some practitioners who, I'm just saying bad things, but I mean, it doesn't apply to everyone, right? Some practitioners that they just go without preparation at all. But there are so many others in all those categories who are good. And I think it's difficult, it's very important to have the feedback. And the arbitration intelligence should be done but by the organizers to filter for next move. But I think it would be very difficult to just reject arbitrators the first time they come without any reference, because organizer would need them to fill in the spots. So I think this is a very difficult. These are very difficult questions. I think there should be some feedback between arbitrators. That I think it would be a very important feedback, especially organizers may already have contact with good arbitrators that can provide feedback to the organizers about how they perceive their co-arbitrators during the hearings. That would be my answer, Cristina.
Thank you.
Can I jump in here, Cristina? Yes, I would agree with Edgardo here that having feedback on arbitrators be coming from the teams themselves or from the co-arbitrators can help the organization in the future put these tribunals together. I agree with Edgardo in a practical sense. You can't reject new arbitrators because they don't have experience. And in the same way, I think it's a tricky position that the organization would be if they were expected to exclude arbitrators who have acted as arbitrators but didn't perform in accordance to what they think is appropriate, because they were badly reviewed by their co-arbitrators in the teams. I think it's an institutional problem and also a human resources problem, because you need those people. And in the end, I don't want to sound like I'm in The Bachelor here, which is a TV show in the United States, that maybe in the feedback you can assess who's there for the right reasons, who is there to show off, or who is there to actually contribute with education. But at the end of the day, everybody's donating their time. For whatever reason they're there, everybody's donating that time, and that should be valued. And Chris told us, and I think that's true for a lot of pre-moots as well, the organization has filters to enable them to put together a tribunal that will make sense. Someone has more real life experience, someone has less, someone's a former student, so and also concerning their background, common law and civil law. So I think that works. If the team's input should be considered in any other way, I don't think so. I think someone, before we actually started this conversation, proposed a system of appointment where teams would be able to make filters. No, I don't want anybody from common law, or I don't want anybody from civil law. I think that's, in practice, that would be hard to implement, but even if it was practically possible, I think that could only work in a system where you can make sure all teams would be treated equally. So if I get to pick at least one characteristic of one arbitrator, I want a common law arbitrator, the other team also has to have a chance. And then the third arbitrator is randomly selected regardless of any filters. But I do think that is hard to put in practice, but I wouldn't have anything against that if equality is preserved.
Okay. Please, Petra.
I actually would like to hear from Charlene at one point on this point as somebody who's sitting in the organizing committee, but I'm actually really wary about any evaluation process because I think, you know, this is also all about diversity. Yes, we have just talked about a lot of what, you know, what a good arbitrator does and what arbitrators should do, but don't underestimate, you know, the diversity also for teams. This is what I wanted to say in regard to feedback. Yeah. So what is a good, fantastic arbitrator for one team might be not a fantastic arbitrator for another. I actually think, and I'm pretty certain, that the mood organizers, whether or not in Hong Kong or in Vienna, will get unsolicited feedback about good or bad arbitrators all the time. And I also do believe that they will react accordingly, especially if there would be an arbitrator who constantly is, you know, diminishes students and doesn't act in the Vis Moot spirit. Any kind of, I don't know, other review of it normally then tends to, it's a little bit like teaching evaluations, you know, tends to push anybody in some middle where somebody decides what's good and what's bad, and actually is nearly against this idea of the diversity and learning that other people have sometimes different methods. So I would be really wary of any kind of, you know, official evaluation system.
And I know from personal experience, there is a lot of information that reaches the organizers about good and deficient arbitrators. So I agree completely with Petra. There are two things, and only two things, that I think would be unfortunate. One is if there was introduced into the process something that distracted the students and the coaches from the arguments they were making. And it strikes me that some kind of formal evaluation or formal ranking of arbitrators for tribunals would create a gaming overlay that does not really advance the educational point of the moot. The only other thing I would say is I don't think that tribunals should pick their own chairs. Because if they do, then it's a certain personality who's going to always insist on being the chair. And someone who insists is usually the wrong person for the job completely. And I've seen it. And to be completely impertinent, it's a particular demographic that always thinks they need to be in the center of the tribunal. Also, a lot of time when there is some uncertainty around that, I push forward the junior person, because we're not just providing education for the students, we're trying to get budding junior folks comfortable in a simulated arbitration, so they then feel more confident in their real life as they start to chase real appointments.
Thank you. Yes, I also think this is a very important goal of the Vis Moot also, the training of next generations of arbitrators. So I don't say young arbitrators because there are some not so young anymore in ages, but they are initiating a new career, or a certain time of the life where you start arbitrating, and it's important. So I say it by myself. I think for me it was a very important experience to go to Vienna and take part in the panels. And also, I think this is part of the question was more rhetorical. I don't know if I agree with an evaluation also, because I think it's all part of the Vis Moot, of the diversity of something that students have to learn how to face. If some arbitrator is there being harassing or so, that can happen also in real life. It's also a challenge for them. They have to learn how to handle with all these situations. So Cesar, maybe now you can go to our closing.
Yeah, we're approaching our time to end this discussion, unfortunately. But before we close, I would just like to ask you all very quickly, if you could, as something like a wrap up, just to comment on what lessons you think you can take away from the experience of being Vis Moot arbitrator for your own professional or personal life. I can tell you myself that all our panelists here were people that I met and learned to admire through the Vis Moot, and so I think that says it all. And it is a great opportunity to have met all of you there and have learned from your example to be a better professional. And but I would like to open the floor for your comments before we close. So anybody?
I'll jump in and say, apart from the learning experience, I have made dozens of lifelong friends, including people like Sherlyn and Louise, not just from fellow arbitrators in the moot, but from students I engaged with in the moot, who remain friends 25 years later after we met in Vienna. And I think that's really powerful and wonderful. And it's part of why I'm always so excited to do the moots, because they're populated with wonderfully interesting, fun people.
Well, Petra?
Yeah, I can't add anything to that, really. Really, you know, it's, you both summed it up. It's a fantastic lifelong friends. Made me travel and see the world, you know, visiting you in Sao Paulo, you know, going to see, spending some time in Hong Kong with Sherlyn, you know, like going to Guadalajara. So it's fantastic. Yeah, it's a real community, and that makes it really special.
Edgardo?
Well, I was a Vis Mootie once 20 years ago, so the moot gave me a lot of stuff. But as an arbitrator in my practice now, I think despite of the fact that the moot can have some bad side on it, or bad experiences for some students, I think it prepares you for life, because such is life. And as an arbitrator in my professional practice, I always try to put myself in the shoes of the lawyers who have done a lot of work preparing their cases. And also I know that sometimes they cannot choose the facts, they cannot choose the law. Just try to respect them, to acknowledge their work, and also their valuable help to their clients. And that's how I see it.
Thank you. And Luisa?
Yeah, I don't have a professional life as an arbitrator yet, but I think there are some lessons that stick with us just by acting as an arbitrator through the Vis. I'd say the two most important ones for me is that it's a good exercise of identifying our own biases and kind of exercising how to not let them get in the way of making an impartial judgment. And it's also a very good humbling exercise, because arbitrators have to be open-minded. Usually you're going to be facing students that are younger than us, that don't have practice. And so we think we know all the right answers and we have all the right arguments after we see the case, but we do have to be open-minded and see that sometimes we're going to be learning. And I think every time we're going to be learning. And well, going back to what Chris says at the beginning, most likely the teams will know better than us. And so it's a learning experience, but also a very humbling experience. And I can, and being in the lessons or good things that stay with them, regardless of acting as arbitrators, are not as obvious to me. I made some of my best friends through this, met my boss through the Vis, who's also sitting in this room with us now, virtual room. And yes, and I learned a lot. And I like to think that a lot of my practice today is also based on what I learned.
Thank you. And Sherlyn?
Well, I got a husband out of it, so that's probably my claim to fame here. No, the Vis Moot, it's professionally, it's great. When you act as an arbitrator, I think one thing that I do like to point out, and you hear it all the time, the arbitration community, while it is international, but at the same time, it's also very, very small. It's a very tight-knit community. The biggest complaint you hear about it is that it's very hard to break in, but at the same time, the other biggest complaint that you hear about it is everything that happens is also easily spread. So I would say what for me, a great takeaway from the Vis Moot is you don't need to listen to all of the rumors or the stories that you hear from other people about certain arbitrators or legal counsel. You have the opportunity to meet them, whether it's in person or virtual. You have the opportunity to sit with them. And as I think we are all aware, people are very subjective. You can rub one person the wrong way and somehow that story is going to get out. But in reality, it was one tiny little story that blew up. With the Vis Moot, you have the opportunity to meet these individuals and get to know them. You get to choose who you can work and want to work with professionally and be personal friends with. So I think for me, that is the biggest takeaway after the husband.
Thank you. Thank you so much. Well, before we close, I would just ask everybody to smile so I can take a picture of you here. Just a moment. Now. Okay, yes, now. All right. Well, thank you. Thank you so much. This has been wonderful. As you know, this has been recorded and it will be made available through the MAA and through the Chartered Institute of Arbitrators. And it is going to be certainly a very important document for the generations of arbitrators that will go through the Vis Moot and the Vis East. And well, thank you so much for your time, and see you next time. Bye-bye. Thanks.
Bye-bye. Thank you all.
Thank you. Bye-bye.